Now we proceed to our first keynote speech of this conference. Please welcome keynote speaker, Honorable Chief Justice Beverly McLachlan.
We also welcome President Xu to host the first keynote speech.
So, good morning, ladies and gentlemen. It's my great pleasure to welcome you to this conference. We are delighted to invite former Chief Justice of the Supreme Court of Canada, Honorable Chief Justice Beverly McLachlan, to deliver the first keynote speech this morning. The topic of her speech is 4 Errors of Aboriginal Law in Canada. The Honorable Chief Justice Beverly McLachlan served as Chief Justice of the Supreme Court of Canada from 2000 to mid-December 2017. In June 2018, which means this year, she was appointed to the Order of Canada as a recipient of its highest accolade, Companion of the Order of Canada. She has received over 35 honorary degrees from universities in Canada and abroad, and numerous other honors and awards. Chief Justice McLachlan is also talented. I was told just last evening, Justice McLachlan has published one novel related to the law, and the novel for 10 weeks stayed in the short list of the best sellers. Is that right? So very talented. I think there's no other Chief Justice can publish novels. So now let's welcome former Chief Justice of Canada, Honorable Beverly McLachlan.
President Xu, distinguished jurists, friends. It is a great honor to be with you here today at this very special conference to mark a very special occasion, the 70th anniversary of the Constitutional Court of Taiwan. You have come a great way in 70 years, as the comments of President Xu, whom we've just heard, illustrate. And it is a proud record, one that has not been afraid to take on, in recent years, some of the most difficult issues in human rights to confront constitutional courts, such as same-sex marriage. And for people like me who believe in the rule of law and in democracy, it is a heartening record. So sincere congratulations. I am grateful today for having been invited because it has given me occasion to reflect on an aspect of constitutional law and constitutional arrangements that has not been much talked about, and which indeed I had not directly reflected a great deal on until I thought about my remarks today. You have a paper, which is a historical background paper, setting out 4 legal eras of relations in Canada with Indigenous peoples. In my oral remarks, I would like to focus on the constitutional implications of that history. Now, Canada was a colonial country. Much of the world, indeed, is what we call a post-colonial world. This is the world that was settled by Europeans in the 18th, 17th, 18th, 19th century, who imposed their European systems, including their constitutional systems, on the people that they found, the indigenous people, or the people who came to settle in these new areas. All of South and North America, and much of Africa and Asia, fall into this category. Europeans came, Europeans imposed their constitutional norms, and that was that. Or so we thought. But indeed, it was just the beginning in these countries of a constitutional journey. And it is so interesting to compare the different journeys that different countries have made as they work toward their own constitutional regimes, and as they came to grips with the fact that in addition to the settlers of European descent, there were indigenous peoples whose rights had to be recognized and respected. The subsequent history of each of these countries reflects a particular constitutional experience. Canada is no exception. The opening assumption upon settlement, when the Europeans would come, was, as I have said, that they would bring their constitutions with them and impose them. And so, in North America, the American colonies were under the Constitution of England. And the King of England was their ruler under that constitutional regime. And Parliament made laws for these colonies. The same was true in Canada. There were fledgling colonies, but the King of England was the head of state, and the Parliament of England was the final legislative authority. Now, as time passed, all of these nations assumed, one way or another, control for their own affairs. Sometimes it was by revolution. Most of Latin America and the United States attained their freedom by revolution. That was an armed uprising against the existing constitutional regime, which was the king or the queen of whatever country had colonized. And in the United States, it was against the King of England, against the control of the British Parliament, and established a new country which would be founded on a new constitution, the Constitution of the United States. In Canada, the path was slower and more hesitant, although the result ultimately was the same, a new independent country. We say that we attained a freedom by evolution, not revolution, gradually increasing the power of local colonies to govern their own affairs, and finally, in 1867, the formation of a union of a number of colonies to form a new country. We did not complete that process until 1982, when we repatriated our Constitution. Until then, the only place the Constitution of Canada could be amended was the British Parliament. And we changed that, along with bringing in a Charter of Rights and Freedoms and protection for other rights, including indigenous or aboriginal rights. So our constitutional journey takes us till 1982 to be finalized and completed. Now, in the course of this journey, whether it is in Latin America, the United States, parts of Asia and Africa, or Canada, one of the issues that the original colonists, colonial regimes faced was how they were going to deal with the indigenous populations. That is, the people who were already there. The assumption was that they would have no special arrangements, that they were conquered peoples or assimilated peoples, and that there would be no provision. So you ask, how is this constitutional? What has this got to do with constitutional law? Well, if we define a constitution broadly as the legal framework in which state power is exercised and citizens' rights and duties are defined, this is a constitutional issue because state power was being exercised over the original inhabitants. Their rights and responsibilities were being defined. And although these arrangements were not labeled constitutional, they had a constitutional character. And I believe it's worth examining what that character was. This brings me to my paper. And in my paper, I describe 4 constitutional stages in the development of relations between Canada's Indigenous and non-Indigenous peoples, and between the British Crown in earlier years and Canada's Indigenous peoples, which took us from the first entry of Europeans onto what is now Canada's soil to 1982, and indeed is still going on. Now, those eras are, and I'll say a little more about each of them, but I define them as 4 eras. The first era is a nation-to-nation kind of constitutional regime. The Indigenous people are treated like nations, and the incoming Europeans are nations, and they make peace treaties and that kind of thing just in the same way that nations would. The second stage is a stage of protection. The Crown constitutionally undertakes to protect and look after the Indigenous people. The third stage is a stage of paternalism. And there's a subtle difference between protection and paternalism, which I'll describe briefly, and I do in my paper. And the fourth stage is recognition of independent status and rights of Indigenous people under the Constitution. Now, 1, 2, and 3 in Canada, the first 3 stages, have never been set out expressly in any constitution document, except that we do find in each of those stages documents that have a constitutional character and attest to the constitutional nature of those stages. For each of these 4 stages, there was a seminal document of constitutional or quasi-constitutional import. The first stage was when people like Samuel de Champlain and other early explorers, there were French, there were British, came to Canada, 1600s, late 1500s, 1600s. And they found a wild country, forbidding country, full of forests and rivers and lakes, no highways except the waterways, and lots of ferocity going on. They found this country was inhabited by numerous groups of indigenous peoples, the Hurons, the Algonquins in the east, the Micmacs. These are names which probably aren't familiar to you, but every Canadian knows them. These were nations that had systems of government. They had wars with each other. They had peace treaties. They divided up their land and hunting and whatever they needed, and they had trade arrangements. And it went all the way across what is now Canada to the west coast, with many, many of these nations who were indigenous peoples. Well, the Europeans came to the east first. They encountered these people. And they treated them, by and large, like independent groups, like independent nations. They made war alliances with them, because what happened was that the British and French were both coming into that part of the world, and they were fighting each other. Americans know all about this too. It happened in their country. And so the strategic thing to do was to align yourself, make a war alliance with one of these groups, and that would help you win against the other. And this was a pivotal factor in the ultimate triumph of the British over the French in what is now Canada. So they treated them like nations, and often they entered into peace treaties with them. Our court had to adjudicate a case based on a Micmac treaty on the east coast of Canada, which was signed after the British had conquered the French in that area. And of course, the first thing the British had to do was make treaties not only with the French government, but with the First Nations people who had fought in that war. And they did. And they made certain guarantees to them that they would have trading posts, etc. And the argument before us was that that gave a guarantee of a perpetual livelihood. And in that case, the court had to rule on what was essentially a peace treaty in this early area. So we had this early era where the incoming Europeans were very dependent on the First Nations to get around, to survive, to know how to dress warmly, to move across the country, to fight with them or against them. And basically the relationship was, in constitutional terms, a nation-to-nation relationship. The second era was the era of protection, and this is particularly in those colonies, such as Canada and the United States, where the king, the British regime, was in place. And this happened, this was the era which was heralded by another document, which is called the Royal Proclamation of 1763. What was happening is that settlers were pouring in, and they were starting to take up lands that the indigenous people had occupied, often on unfavorable terms or without paying anything at all. So the king in England, the parliament in England said, we are going to prevent this exploitation. We are going to protect these people. And they passed the proclamation of 1763. Now, in fact, it's not much talked about, but some historians have pointed out that this was a factor in the American Revolution, because what it said was this. It said, you can no longer take land directly from the indigenous people. Constitutional in nature, I think. And it said, the government, the British government, guarantees that they will negotiate with the people, they will look after the people, make sure they're getting properly constituted. So the government acquires the land and then passes it on to settlers. And so nobody can acquire the land directly because that involves war and exploitation, but the government will take the land, it holds all the land, it simply declared it did, and we will pass it on to you under terms, and we will look after the indigenous people, ensure that they have places to live and get proper compensation. So that was the idea of the Royal Proclamation. It didn't sit well with people like Washington and Jefferson, who had already explored huge tracts of land beyond the Allegheny, and they decided, with that and taxation and other grievances, to have a revolution and get out from under the British. In Canada, the Royal Proclamation continued, and so there was, for the Maine, no direct acquisition by individuals of indigenous land. The British government owned it all, and they made treaties with the Indians, which set up blocks of land called reservations where the Indians could live, and then opened up the remaining land for settlement. Now, this was done consensually. It was a contract regime. But it was a regime overall of constitutional protection, as I would call it. Now, that morphed into the third phase, which I call paternalism. And protection became paternalism when Canada was created as a nation in 1867. The demands of settlement and settlers were increasing very, very rapidly. The government needed land to distribute to settlers. It needed land to build a railway across this vast 3,000+ mile territory. And it had a problem. It had indigenous peoples in place all across the country. And it followed the treaty model that was required under the Royal Proclamation. It entered into negotiations and entered into treaties, except in the far west province of British Columbia, where that process was, for different reasons, always aborted. People just took land, and now we have an ongoing claims treaty process going on in British Columbia because it was delayed so long. But what came along with the new government was something called the Indian Act. And if you are an Indigenous person in Canada, it's pretty probable that you don't think too highly of the Indigenous Act. The Indigenous Act assumed a protective regime, basically treating Indigenous people like wards of the state. They had to be looked after. They were on reservations. There were periods of time when they could not even leave the reservations. They were not granted voting rights until 1950. In this and many other ways, there was a very paternalistic way, attitude. And so again, that's another kind of constitutional relationship. We're not treating you like full-fledged citizens. We're saying, you've got some sort of special status as people who need to be protected and will protect you. Problem was the protections were not always adequate. Problem was, in the early days, they were seeking assimilation, and they established residential schools, taking children away from parents, which has created a huge blot and much suffering, and which is now being addressed even today by the government in reparation measures. And the problem was the basic denial of many rights, rights of mobility, right to vote, and so on for a very long time, almost a century. So this was the third period. The fourth period, and I must wrap up soon, was the period we're now in, with 1982, with the new Constitution, repatriation, and at that point, a new constitutional regime with express constitutional protections for Indigenous people came into being. And Section 35 of the Constitution Act, 1982, provides that the rights of Indigenous Aboriginal people, as they're called, are constitutionally protected. It didn't give a lot of detail. It just said they are constitutionally protected. Now, this has led to 30+ years of very interesting work. Lord Bingham once opined, the great British judge and writer, that to protect human rights you need two things generally. You need a written constitution, even though Britain didn't have one, but it had at that time the European Union model of the Bill of Rights. But to protect, you need a written, to really have protection, I think, and I agree with this, you need a written Bill of Rights, and you need independent and impartial courts which provide a minimum, which enforce those fundamental rights. And that is what the Aboriginal people of Canada finally got in 1982. And since then, there has been an exponential development of Aboriginal rights and Aboriginal and Indigenous jurisprudence. The ball has shifted to the courts to define these rights, and the courts have been extremely working. Now, my time as a judge from 1981, the year before this happened, till when I retired, just matched this, paralleled this time of development. And this has been one of the most interesting aspects of my work, and I feel very privileged to have engaged in what is really the articulation of the constitutional rights of Indigenous peoples. And these rights are a number. The first cases to come to the court were cases dealing with Indigenous practices, hunting rights, fishing rights, religious rights, burial grounds, religious practices like most of these had already not been outlawed, but in the early years, the Sundance was outlawed, the potlatch was outlawed, very central traditions to these people. They were told they'd go to jail if they continued them. And so we've had many cases in the 80s and 90s, and we still have them, about the articulation of these practice rights, economic rights. The second kind of rights were land rights. And this became important in British Columbia, where, as I mentioned, they had not had treaties. So suddenly there were land rights and land claims and all that. There's a land claims negotiation process. There are court cases about it. And this has proved immensely difficult and complicated, but we are working our way through it. A third category has been rights to compensation and apologies for past injuries and injustices. The denial of human rights in the past, and I've already talked about that. The devastating impact of residential schools repeated successively into new generations, which is much written about in Canada. We just had an amazing Royal Commission on this, Truth and Reconciliation Commission, and we're working that out. Another thing the courts have been called upon to do is to define who is an Aboriginal. And is it, there's been a lot of intermarriage. There's been a lot of things happen over a couple of centuries, 2 or 3 centuries. And so is a Métis person, that would be somebody who identifies as both Aboriginal and European, are they under? We said yes. So because there's a bundle of constitutional rights with economic rights and other rights flowing from that, people want, and because of the way they feel about themselves, identify themselves, they want to be identified. And so the courts have been involved in a series of those cases. And then more broadly, we have engaged in a broad task of trying to reconcile Aboriginal and Indigenous legal practices with the European origin practices that are in force in our general law. And so things like sentencing circles, things like interactions between victims and people accused of crime, these are coming, we are working to bring these into the mainstream of our law so that Aboriginal people do not feel the system is an alien system, which is too often the case, but a system that they are part of and that they can identify with. And more broadly, there is a task of reconciling Aboriginal rights and interests, be they land rights, for example, with other Canadians' rights. We are now engaged in this process with respect to a pipeline which is proposed from Alberta to Vancouver. And it has been the subject of many court decisions and continues to be the subject of decisions and boards and protests and so on. So this is a process we call reconciliation. What is reconciliation? Reconciliation recognizes that, as Chief Justice Amer said in a landmark case on land rights, Delgamuukw, we are all here to stay. We cannot roll back the clock of history. We are all here to stay. We all have basic human rights. We all have our own particular rights as members of society, and Indigenous people have their particular rights. The only way forward is reconciliation. It's messy, it's complicated, it takes a long time, but it's very, very important. And so Canada is now engaged in a constitutional journey of reconciliation where Indigenous rights will become reconciled with non-Indigenous rights so we can move together as a nation. Thank you very much.
We thank Honourable Chief Justice Beverlyn McLachlan for her enlightening speech.